time, let the record reflect we're taking up an action that is styled Commonwealth of Kentucky versus Stephen Eugene Lawson. It's 23 CR 165 and 23 CR 371. Mr. Lawson is present with counsel. Mr. Wolf and Mr. Butler also present on behalf of the Commonwealth or special prosecutors, Mr. and Ms. Young and Mr. Lasowski. I believe there's several matters that are pending on today's date. I believe the first motion that was filed was in regard to DNA testing of two hairs. Is that correct?
Yes, sir. May I please report?
Certainly,
Judge, I think I can short circuit this because we're going to remand this motion this time. I'm going to explain to the court why.
Okay.
Initially, when me and Ms. Young and Mr. Lasowski first come across the court order, which come in KSP notice and lab reports, we had not realized there were two hairs that hadn't been tested. And I got freaked out by it, to be honest with you. So I hurried up and filed a bunch of stuff before I really sit down and talk to the chemist himself. And we've had a chance to actually talk to the chemist and speak about it. And once we learned the hair's lengths and the colors of the hair, which one hair was approximately 8 inches, the other was approximately 12 inches. And the hair was a brown tan that had been chemically treated, which usually comes along with female, the majority of the time females. That is not.
You don't think I color my hair?
Well, that's why I look like I do now. But they're not going to belong to either Mr. Lawson or Mr. Lawson's son. We would anticipate Brooks Hout's hair being in the car because he used the car. So we're going to go ahead and stipulate that the two hairs don't belong to either of the Lawsons. And I don't really want to spend the state's money because of what it was going to cost to have expedited testing, to have them come back and tell me the same thing, which based on the visual analysis, if they would have had hair samples from them back then, they would have excluded them to begin with on the visual analysis and would not have performed the.
So that takes care of your motion for,
yes,
so that motion's remanded. I believe there's a motion on to continue that has been filed by Mr. Lawson. Is that the only other motion pending here today?
It is, Your Honor, but I believe that we would still like to address the DNA motion made by the Commonwealth and ask the court that in our response to construe that as also a motion by the defendant to be afforded the opportunity to have these hairs analyzed, irrespective of whether there's a stipulation that it's Mr. Lawson, our client, or Mr. Joseph Lawson, his co-defendant. These are not hairs that were located at a location that bears little to no nexus to this case. They were located in the alleged victim's automobile, which is a center point of prosecution against our client, certainly. It stands to reason that the hairs may not be either Joseph or Stephen Lawson, but regardless of that, if the identities are unveiled to be somebody else who's been identified as a suspect in this case or someone involved in this case, that could fundamentally alter our defense strategy, to be sure. Moreover, we appreciate and have no reason to doubt the Commonwealth's representations to the court today that they have consulted with a chemist and that they don't believe the hairs to be belonging to either our client or to Mr. Joseph Lawson. But we cannot, in good faith on behalf of our client and do due diligence by relying on those representations. We would still need to conduct a separate analysis through our own experts, which we've recently retained in light of this litigation. So our request articulated in the response would be the same that we would request from the court today, and that's that we have the opportunity to analyze this. It doesn't sound like it's necessary to have a separate hearing to determine what the appropriate testing method is if the Commonwealth has withdrawn that motion. But certainly we'd like to have an opportunity to inspect the two samples, have our expert inspect the two samples and determining what type of testing, if any, is feasible, and whether sample consumption is inevitable or not. That's effectively what we requested in the response, short of the adversarial hearing between two experts to determine what type of testing would be appropriate. So as it relates to the DNA issue, Judge, I think that is our request on behalf of Mr. Stephen Lawson.
Competency response.
Judge, there on one lip there was 43 hairs. And
I'm sorry, on what?
They're on one tape lip. The report there's hairs I didn't realize, I guess in my car was probably as many hairs too, living on a farm, but a lot of the hairs were animal hairs. But you go ahead and say they go ahead, I mean, we're stipulating it's not them, okay? I mean, that's their defense. So if they want to use it as, there's another person out there that could have done it or whatever, but you don't have anything to test it against. That, you know, so that doesn't make, we're stipulating it, and I'm telling Your Honor, what this is doing, what they're trying to do is delay this trial. They want to go behind Mr. Howe. There's some tactical advantage they figured out, and I think this is done in conjunction with Brooks House attorneys, that they want to go last. Because it benefits, the only person it benefits is Brooks Howe. And we're willing to stipulate to it. The defendant has admitted he was in the car. He's admitted he was in the car in front of his counsel and me. His hairs may have been in the car. I don't know. But what we're saying is these two hairs, we know for a fact they don't belong to them because of the length and the color. And there's no reason at all to delay a case that has been pending for 10 years.
Well,
Your Honor, may I briefly respond?
Yes,
I apologize, Your Honor. I don't mean to interrupt the court. Judge, these hairs have been in the custody of the state for nearly 10 years. It is not the fault of Mr. Stephen Lawson that they're being brought to our attention in March of 2025. If the Commonwealth wishes to speculate that we're co-conspiring with a co-defendant's counsel, so be it. But ultimately, the case law that we've cited, McGregor v. Hines, which is a Supreme Court case with the Kentucky Supreme Court, our client has a right, be it inculpatory or exculpatory, to test these hairs. He has the right to that independent test. It's an implied right found to be through Kentucky Rule of Criminal Procedure 7.24. They may be immaterial, but we can't speculate on the materiality of evidence that has not been analyzed or subject to forensic analysis. That's the reason we do it. And if we simply say that we'll agree to waive our right to exercise separate analysis of the test, then that ultimately jeopardizes our client's defense strategy. We don't necessarily know who the identity is. And there may not be an identity yielded from it, but that doesn't defeat the fact that he has a right to have these samples tested. And the case law and the rule supports that.
well, I don't see how you're going to match it up with somebody else if there's nobody to match it up with. That's the problem I see here. I mean, they're telling you, they're admitting that it's not his hair or any co-defendant's hair. So I would certainly give you an opportunity to have your expert look at it. If he wants to present some type of testimony about it, I really don't think it's particularly relevant if they're saying it's not any of the co-defendant's hairs. So.
And we can arrange for them all to look at it. That's something.
Yeah, if you want to have your expert go look at the hair, certainly talk to Mr. Young and you all can go and look at the hair, but I don't know what good it's going to do to test when they're telling you that it's not their hairs and you don't have anybody's sample to say we're testing to see if it's this person.
Well, Judge, we don't know if it's not our client's hair. We don't, that's the whole point here, is we do not know whose hair
So
it
you
is.
want to test it to see if it is his hair? To put him in the car?
With all due respect, Judge, you don't know our defense strategy. So depending on what the results are, that could absolutely change what we are planning on doing from a defense standpoint. And with all due respect to the court, I really do not want to state on the open record in front of anybody, specifically the Commonwealth, what our thoughts are on what our defense is. So I'm going to respectfully decline to answer your question about whether or not I want it to be my client's hair. I'm not going to answer that.
And his client's admitted to being in the call.
Okay. I'm denying the motion for any testing because there's nobody to test it against. They're telling you it's not his hair, so I don't, and apparently it's not the same color, it's chemically treated, but I'll allow your expert to take a look at the hair if they want to look at it. Okay.
So is it the court's position that the Commonwealth can state on the record that it is not our client's hair, and the court takes that for it not being our client's hair? I mean, that's what I'm
letting you look at the hair, and if you come back and you tell me that the hair is not chemically treated or the hair, something that they're saying is false, I'm allowing you to look at the hair, and if it's a different color or something of that nature, I'm giving you an opportunity to look at the evidence.
Right.
But I'm not going on this fishing expedition of having it tested and we don't have anybody to test it against.
With that said, Judge, I would anticipate after our expert looks at the hair that we will want to do an analysis of that hair. So maybe now's not the right time. And if you tell me it's not because we don't have enough information, perhaps what we need to do is get our expert here and explain to the court what type of testing could be performed and what type of end result you may anticipate depending on those particular results. I'm not a DNA expert, and I know counsel's not a DNA expert, and I sure know the Commonwealth is not a DNA expert. So I think we're taking and making some significant leaps here without any testimony from somebody who has expertise in this particular
If
area.
you want me to have somebody come from the lab to testify that it wouldn't be their hair and the reason why, I'll be fine doing that. But at this point, I don't see any reason to have this hair tested if they're going to tell you it's not any of the co-defendants.
But I just don't think they have the ability to do that, Judge. They don't know that. Just because Mr.
I said I was going to take testimony on it. I'm willing to give you testimony on it, is what I'm saying
Okay,
there.
very well, Your Honor. I'm uncomfortable with taking the statements that a Commonwealth attorney has spoken to a chemist, and now we are all concluding that the hair is what they say.
If I said I'd give you a hearing on it and let the person testify, I'm not making a finding here today at all, but I take Mr. Young at his word. He's an officer of the court. He's not going to come in here and misrepresent things to us.
No, and Judge, what the chemist said was, he told us what the length was. He told us what the color was. He told us it had been chemically treated. We know what color Mr. Lawson's hair was then, and what Mr. Joey Lawson's hair was then, and the approximate lengths of their hair. It can't be their hair.
Well, like I said, I will have the person show up and we'll take testimony on it. And at the end of the hearing, I'll make a finding on it.
And Judge, are you, when you say the person, are you referring to the chemist?
The chemist who says it's not their hair.
All right, well, we would like our expert, of course, to potentially testify as well. So we just need enough time to arrange for him to be here at that particular hearing.
Okay. Do we have any other motions today?
And Judge, just so we can be clear, I am trying to struggle here about how to articulate a response to a claim by the Commonwealth's attorney on the open record in front of the media, this court, and everybody else, that he has now determined that there is some conspiracy between the co-defendants to delay the trial. I'm offended by that, Judge, and I'm going to ask the court that in the future, if he doesn't have the ability to back up such statements, those are, to me and my counsel and to my client, those are inflammatory statements. Out of respect to the court process, I didn't get up and object when he made that statement. But I want the court to know, and I want counsel to know, that those don't go unnoticed by us. That was inflammatory, was not appropriate, and in the future, we're going to ask the court to strike that from the record if he ever makes such claims again in the future.
Judge, we would also ask counsel to not file motions at 4 in the morning before the hearing and abide by the court rules.
We would ask that, Judge, that they not find hairs on May 25th.
Let me see you two up there. Come on up.
Judge, give me a second. I need to mute you there.
Okay.
Judge, you need to hit the unmute button on the box. Yeah, right there.
Okay, when y'all came to the bench, everything was muted, so people on Zoom can hear what we're doing again. Go ahead, I'm sorry.
All right, Judge, just to confirm where we're at, we're asking the court to set a hearing for a discussion related to whether or not it is relevant and or necessary for the 2 hairs that were found and disclosed by the Commonwealth on March 25th of 2025. And we, at that point in time, anticipate bringing witnesses, or perhaps one witness of our own. And we also anticipate that the Commonwealth will be bringing the chemist. The counsel for the Commonwealth has stated on the record, states X, Y, or Z related to said Harrison.
Okay. When can your expert go and view the hair? Was the hair at the
Frankfurt lab?
At the Frankfurt lab. When can your expert go and do that?
I can tell the court that when we get out of here today, we will contact him. There's really I don't have his schedule. So
I'll tell you what, why don't you go make a phone call and find out, because I want something done the next 2 weeks for this hearing, so.
I will attempt to contact him. May I step out, Your Honor?
Yes, yes, certainly.
Judge, I was informed by his staff that he is out of town until the end of the week, and I have left him a very long, lengthy voicemail asking him to call me back as soon as possible.
Okay, well, if he wants to review the hair, he's got to be available next week, April 7th to the 11th. Arrange a time to go view that hair. Just contact Mr. Young with what time during business hours he wants to go next week. And I'm looking at setting the hearing the following week. What about April 14th?
Yes, sir.
I can do morning or afternoon.
Either one's fine.
Your Honor, I would just request it to be in the morning if it's on April the 14th, because my afternoons.
Sure. 9 a.m. okay?
I'll defer to Mr. Lawson on his schedule for the morning of the 14th, Your Honor.
I'm good.
You're good?
Yeah.
Okay, Judge, I think we're available for the 14th in the morning.
I'll put down the hearing will be at 9 a.m. on April 14th over the hairs. All right. Anything else we need to take up to that?
And just, I don't mind drafting it, we probably need, the lab will probably need to order.
Sure. If you will draft a order that says that that the defense expert has a right to come and view the hairs, and that's to be arranged through a date sometime between the 7th and the 11th during business hours, and they're to contact the experts to contact. You want it to be direct to the lab, or do you want to be the in between?
I don't know who the expert is. The lab guy may know him. I don't know who it is, but they can call me. That's fine.
That they contact you to arrange the time for this. Okay, if you'll tender an order that, I'll be glad to sign it. Anything else?
Judge, we have an opportunity to review that as well before it's signed.
Yes, if you'll email it to counsel, and you'll have an opportunity to review it.
Judge, we also have a motion to continue the jury trial, given that we are going to be having a hearing in the near future. We ask that that motion be passed to that particular date.
I do have one thing, if it
Sure.
can. I did call I was concerned about, Mr. Lawson not having, because they said they'd asked EPA to buy him a computer, and That hadn't happened yet. So I called the jail and there is a computer available that Justin, Mr. Hall or Jailer Hall says he would make available anytime, but we actually brought a computer. It's a computer at the office. It has nothing on it. We'll give it to him. We just ask for it at the end back. It can stay here. He can come here. He can use the computer.
Well, I tell you what, this guy over here knows about computers.
Yes.
So-
So we'll give it to him. So it'll be here anytime they want to use it.
Okay. I'll show them there's a computer available. You all just tell me what days you want him brought up here and Timmy will set it up in the back and he can look through the discovery at it.
Yes, and I would, obviously, we would like to see the computer. I just want to make sure that, as you know, there's some security concerns. So I want to confirm that we do not have any Wi-Fi access, that there's nothing else on the computer. Those are things that I and/or our expert related to.
Do you have the computer here today? Okay, well, why don't you all view it before you leave then?
Yeah, I'm not qualified to tell you whether or not it's got the, meaning, you know this as well as I can, Judge, we have other people involved in our team that can tell us whether or not that's an issue. So, but I appreciate the offer. So let's leave it here. Here's my suggestion. Let's leave it here. And before we make arrangements, and I have one of the sheriff's phone numbers here, and I've communicated with him about not wasting anyone's time bringing Mr. Lawson over until there's actually something there for him to look at. How about we just do this? They leave the computer, we come look at it, or have whoever else look at it to determine that it's an appropriate computer to use, and then I will communicate with the sheriff and have Mr. Lawson brought over at the appropriate time. Again, I'm not trying to waste anyone's time.
I guess I don't understand what makes it an appropriate or inappropriate computer. I'm not following here.
I haven't even seen the computer, Judge. I don't know if it has the appropriate
If it
things
works and
to accept the discovery. I don't know. I don't know if it has any connecting ports on it. I mean, I just don't know.
It's what we've been using.
I think they got it here if you want to look at it. I mean,
Okay.
Judge, it has Adobe on it and it has VLC media player, so they'll be able to view it. As long as they don't hook it to Wi-Fi in the building, I don't know how anyone would have any Wi-Fi access. I don't know the code for the Wi-Fi, so I can't put it on here. So certainly somebody can go in the settings and look and see if it's hooked to the Wi-Fi in the building. Other than that, it won't have any access to anything outside of what he's viewing on the computer.
That was a concern of the courts, of course. So I was just trying to address your concern.
that is a concern of any contact with people through any type of social media would be a concern.
Yes,
to the
sir.
court.
So I was trying to be respectful of your thoughts on it. So-
That certainly would be something he should be having access to. Okay, anything else? Okay, I'll see everybody then April 7th at April 14th at 9 a.m.